School of Medicine. I did my residency in the field of anatomic pathology at the Detroit Medical Center. I then did my fellowship in the field of forensic pathology at the Wayne County Medical Examiner's Office. At the conclusion of all that training, I became board certified in both anatomic pathology and forensic pathology, and I have remained employed at the office ever since my training.
And what is your present title in the office of the Medical Examiner?
My present title is the Deputy Chief Medical Examiner.
That's for Wayne County?
Yes.
Just for the record then, the Wayne County Medical Examiner's Office conducts a majority of autopsies requested by Monroe County law enforcement, is that correct?
Yes, the Monroe County Medical Examiner is the Chief Medical Examiner of Wayne County, and there is a contract so that the Wayne County Medical Examiner's Office performs all of the autopsies that are needed for Monroe County.
Thank you. Now, do you have any ongoing training, continuing education?
Yes, I have to have continuing education to maintain my medical license in the state of Michigan.
And what are your licensures?
I am licensed to practice in the state of Michigan and the state of Washington.
Do you have any teaching experience?
Yes, I have quite a bit. I am the site supervisor for our fellowship. I am responsible for all of the rotators through our office. That's pathology residents, occasionally emergency. Yes, I am.
Roughly how many times have you been published?
I believe I'm up to 10 publications within the last few years.
Can I approach the witness?
Yes.
I'm handing what's been marked for identification as People's Proposed Exhibit number 10. Do you recognize that?
Yes, it is a photocopy of the CV that I provided to the prosecutor prior to my appearance today.
Does it fairly and accurately reflect the testimony that you've given today along with a fuller detail of your background?
Yes.
So I move for admission of People's Proposed Exhibit 10.
No objection.
Have you previously testified as an expert in the field of forensic pathology?
Yes, I have.
And you care to recall how many times you testified as an expert?
It's been around 400 times.
How many?
400.
Oh, okay. And is that all in a variety of courts throughout the state of Michigan?
Yes, that would be throughout the district, circuit, and family courts in southeast Michigan, as well as federal court for the state of Michigan.
All right, thank you. I move that Dr. Levy be admitted as an expert in the field of forensic pathology.
No objection. She is. Thank you.
Now, did you conduct a post-mortem examination of Chelsea Bruck?
Yes, I did.
And when did you do that?
On April 25th, 2015.
And where was it conducted?
At the Wayne County Medical Examiner's Office.
Did you conduct a full autopsy in the way you would normally do so?
Yes, follow the standard procedures for cases of this type.
Right. And at the conclusion of your examination of the body, were you able to form an opinion regarding the cause of death?
Yes.
And before we get to that, can you describe for the court the nature of any traumatic injuries that you found?
The traumatic injuries that were present on Chelsea were all fractures present on her face and head. Specifically, there were nearly symmetrical fractures of the maxilla that extended up into the inferior and medial orbits. In layman's terms, those are fractures of the facial bones near the nose that extended up into the eye sockets. And again, those were nearly symmetrical. There was also a midline fracture of her mandible, which is the jawbone. This fracture was not vertical, it was slightly slanted or oblique. And then there were two fractures present on the right side of her jaw, where the joint or jaw socket is located. Specifically, that was of the right ramus and the right coronoid process. She also had two chipped and or broken teeth. The left upper central incisor tooth was broken, and the left upper lateral incisor tooth was chipped.
Your Honor, may I approach the witness?
Yes.
The Hindu has been marked for identification as People's Proposed Exhibit 3. And let's get to take a look at that for a moment.
This would be a scene photograph of the remains of Chelsea Brooke. In this photograph, we see her head, her neck, shoulders, and upper chest. She is lying on her back. And in this picture, we can start to see the fracture that was on the midline of the mandible.
Yeah, I guess if you would, just so the court can see, maybe point to that spot where, unless you already did so.
The fracture would be here. Were completely skeletonized. There was only some skin present left on the back of her head and her neck. So this photograph shows not only the condition of her body, but the one mandible fracture, as I've described.
And is the deterioration in her body consistent with the fact that it appears she had been left out to the elements and so forth for a number of months?
Yes, this is the condition that we would expect in a body exposed, and the loss of skin, organs, and tissue would be through either decomposition and or scavenging from animals.
The move for admission of People's 3.
Any objection?
No, Judge.
Submitted.
Thank you. Now I'm going to hand you what's been marked for identification as People's 4. And ask you to take a look at that photograph and describe what it is for the judge.
This is a scene photograph. This one is a close-up of her head and her neck, showing more the right side of her head. In this photograph, you can see at least one of the right-sided jaw fractures.
And just, if you wouldn't mind pointing that out to the court so you can see.
Certainly, in this photograph, this here is the right ramus fracture.
And are you able to detect in either of those photographs damage rather to the periorbital bones?
No, that is not visible in those photographs.
I would move, actually, before I do that, does that photograph fairly inaccurately reflect the damage to Ms. Brooks' face?
Yes.
All right. And I would move for admission of People's 4.
No, Judge.
Submitted.
All right, and now, were you able to, based on your examination of her back in April 2015, were you able to determine within a reasonable degree of medical certainty, forensic medical certainty, as to the cause of death?
Yes.
And what is your opinion?
The cause of death is blunt force trauma to the head.
And now, you prepared a report in this matter, is that correct?
Yes.
And actually, just to be clear about that, you initially did not release the cause of death upon completion of the autopsy, is that right?
Yes, that is correct.
Why was that?
We had completed the examination of the body and were able to correct the death certificate and issue the autopsy report in June of 2015. The Monroe County Sheriff's Office contacted our office and asked that we do not publish the cause of death or the report because this was an active and ongoing investigation and they did not want to potentially compromise it. The Chief Medical Examiner for Monroe listened to this request and decided to honor it. So we kept the case pending and did not issue the report until the Monroe County Sheriff indicated that doing so would not compromise any investigation.
All right, thank you. So your report actually was authored or released, is it fair to say, maybe July the 25th of 2016?
Yes, that is correct.
Now, first of all, there's reference in your report to possible asphyxiation, and that you can't rule that out. Can you describe that for the court?
Certainly. Anytime a young female is found and has been killed, the possibility for strangulation or asphyxia must always be considered and ruled out. In order to examine a body for strangulation, we look at several things. We look at the facial skin, the eyes, the tissue lining the eye sockets, the neck skin, the muscles and blood vessels in the neck, as well as two bony structures in the neck, the hyoid bone and the thyroid cartilage. In this case, because of the decomposition, all of these items were not present. So we could not exclude asphyxia as a cause of death or a contributing cause of death in this case.
And are you able to determine, within a reasonable degree of medical certainty, when the damage to her face occurred?
These are perimortem fractures, meaning that they occurred shortly before or shortly after death. These were not postmortem fractures, and these were not remote antemortem fractures.
So let's talk about the damage to her face and the blunt. You regarded it as blunt force trauma, is that correct?
Yes.
Now, are you able to give an opinion with respect to the amount of force that would have had to be exerted to cause that level of damage?
All three of the areas that are fractured, again, the bilateral fractures to her face, the midline fracture to her mandible, and the fractures on the right side of her jaw, all would require a significant amount of force to inflict, either things that we see with an assault or a motor vehicle accident.
Would it be consistent with the use of an object as opposed to bare hands, for example?
Yes.
So now I'm going to hand you what's been marked and admitted as Exhibit Number 1, if you would take a look at that. And in particular, I would just like you to take a look at the position of the body, where she was found, and the branches that were placed on top of her.
Yes.
And then I'm also going to hand you what has been marked as People's Proposed Exhibit Number 2. Which is a little bit different view of the same thing.
Yes.
All right. And there has been reported that the one log that is located on her upper torso, chest area, was approximately 9 feet long. And I believe Detective Soroka testified it was between 125 and 150 pounds total, although he admitted that they didn't have a weight scale out there at the scene. With that in mind, do you believe that the damage that was done to Chelsea's face could have been caused by that branch?
Looking at these photographs and the size of the log that, again, is the one that is lying across her chest, in theory, an object that heavy and large could cause at least some of the facial fractures. One blow with an object like this could not account for all of them. And this particular log I see is lying on the chest. And if this log was enough to cause essentially crushing of her central face when it struck, I would expect a similar type of injury to be present on her chest. In particular, I would expect to see fractures of the ribs. The ribs are much easier to break than the facial bones, and she did not have any rib fractures present. So in theory, an object this size could explain some of the facial fractures, but looking at the position of this exact log on her body, I do not believe that it caused her fractures.
Right. We'll take this one back. Now, there's been some testimony that Chelsea, earlier in the night, had been at a party and appears to have walked into a pavilion or a wooden structure of some kind. And witnesses have testified that she may have caught this, some sort of a, brace or something on the pavilion across the bridge of the nose. Would that in any way, shape, or form have been sufficient to cause the damage that you see before you now?
No. Her nasal bones were present and they were not fractured, so she did not break her nose with that supposed injury, and that injury could not account for the facial fractures that were present.
All right, then let's turn for a second to the asphyxia notion here. There has been testimony that the defendant claims that during a sexual episode, he choked Chelsea Brock for a period of, I believe the testimony was 20 to 30 seconds. And his claim is that she was dead after that period of time. Based on your knowledge and training and expertise, within a reasonable degree of medical certainty, do you believe that that choking for 20 to 30 seconds would cause death?
No.
And could you explain that a little bit more fully?
Certainly. In order to strangle or choke someone, referring more to the actual act of strangulation, it is an act that takes more than 20 or 30 seconds to result in death. There is first a period of struggle. This is where the constant pressure cannot be maintained on the neck because the victim is struggling. This period, there are a lot of variables, the size of the individuals, if there's any intoxication, if there's any degree of incapacitation with other injuries. So we do not know how long that phase is, but once constant pressure can be maintained on the neck, the individual will lose consciousness within seconds, within 20 to 30 seconds. The constant pressure then has to be maintained on the neck of the unconscious person for an additional 2 or 2.5 minutes. That is how long the brain cells have a reserve of oxygen. And then once the oxygen reserves are depleted, the cells irreversibly die and the individual dies. If you release a neck after someone has lost consciousness, they will wake back up.
Would that have to be 2 to 2.5 minutes of constant pressure?
Yes.
And the constant pressure around the neck effectively does what?
It depletes the oxygen supply in the body. The brain is the organ of the body that is most sensitive to oxygen. So we always look at the brain cells and how long they can last. They can last 2 to 2.5 minutes without oxygen before they will irreversibly die. Now, this is a spectrum. If someone loses consciousness and you let go of their neck immediately, they will wake back up. But if you hold for an additional 45 seconds, minute and a half, there is a point of no return in which they will have to be resuscitated in order for them to wake back up. But all total, again, the act of killing someone through strangulation actually takes several minutes.
And is it fair to say that in addition to oxygenated blood not reaching the brain, there's also buildup of carbon dioxide in the brain that cannot be released?
Yes.
And would that also contribute to the cause of death?
That's part of the asphyxiation.
One more, please. I'm not sure if you mentioned this. If you did, maybe I forgot it. Did you also find damage to a tooth?
Yes, 2 teeth. The left upper central incisor tooth was broken and the left upper lateral incisor tooth was chipped. So there was damage to 2 teeth.
Okay. And does that play a factor in your belief that this was multiple blows to the face?
The broken teeth would be a part of the blow to the central portion of the jaw.
Thank you. No other questions.
Cross.
Thank you, Judge. Dr. Laverty,
Yes.
how long have you worked at the office of the Wayne County Medical Examiner?
Over 18 years.
And over that 18 years, do you have any estimate as to how many autopsies or death reports you may have participated in?
Over 7,000.
Of those 7,000 autopsies, were there any involving injuries which occurred during autoerotic asphyxia?
Yes.
How many of those do you believe you may have participated in?
Well, I'm going to object as to this line of questioning. There is no evidence whatsoever that Ms. Brock conducted an exercise in autoerotic asphyxiation.
Judge, I think it's a term of art. The testimony that we have heard consists of the police introducing a statement allegedly made by the defendant indicating that he was involved in a sex act with Ms. Brock. She has to be strangled.
I think there's enough evidence for him to question on this, because she's ruled out asphyxiation in general in her testimony. So I think it's was part of proper cross-examination. Go ahead.
Judge, I respect your ruling. Really where I was going with that is I believe, and maybe we can get it from the witness instead of from me, but I believe autoerotic asphyxiation is more of a one-man operation, so to speak, whereas erotic asphyxiation apparently would involve two or more people. And that's all I was.
Oh, well, I haven't heard the answer, so I don't
Okay.
know. I'll reserve ruling on
All
that
right.
then. I'll reserve ruling on it until I hear her answer.
Thank you. Let me clarify this, Doctor. Do you believe autoerotic asphyxiation is just one person?
Yes.
And what is the term for two people involved in asphyxiation as part of a sex act?
Well, I only see the outcomes in which the individual dies, and then that would be strangulation.
Okay, so if it's part of a consensual sex act, the death would be ruled strangulation?
Yes.
During your time in the medical examiner's office, have you seen any types of injuries related to that?
To strangulation, yes.
Okay, how many do you think? You said you've done, what, 7,000?
I have probably autopsied over 50 cases of strangulation.
Okay. And who is the chief medical examiner these days?
Dr. Carl Schmidt.
I see. He's been there for quite some time.
Yes.
Now, in this case, you actually, I take it, although it's kind of unclear, you actually looked at the body itself, correct?
Yes.
And that was taken into the morgue?
Yes.
Did you do all the work on it, or did somebody help you with that?
Well, we have technicians that help with the photography and the x-ray of the body. We send out the toxicology samples to NMS labs in Pennsylvania. We have the identification done by in this case, a forensic dentist who's under contract to the office. And because the remains were mostly skeletonized, we had our anthropologist also examine the remains.
Okay. Would that be a person by the last name of Moore?
Yes, Dr. Megan Moore.
And she actually works for your office?
Yes, she is under contract to our office.
I see. And her examination, was that of just the skeleton?
Yes, correct.
And did you review her report when you prepared your report?
Yes.
As far as the skeleton goes, was it complete or were there pieces missing?
There were some pieces of the skeleton missing, specifically the hyoid bone, which is in the neck, and some of the bones that comprise the left foot.
The left one.
The left foot.
Now, the hyoid bone, is that an important aspect of doing an examination related to strangulation, the hyoid bone itself?
Yes, that is one of the internal injuries that we look at when considering asphyxia or strangulation cases.
And in this case, that bone was simply gone, correct?
Yes, correct.
What would you expect to see in hyoid bone if the death had been by strangulation?
In a 22-year-old, we would expect actually to see no fractures. It is a fallacy that we see fractures relating to the amount of strength. If we see fractures, it's due to the age of the victim. So in a healthy 22-year-old, we actually would not be expecting to see fractures.
And could you tell the court what a hyoid bone is and where it's located?
The hyoid bone is actually a U-shaped bone with the back of the U pointing towards the back, and this is located up at the very upper end of your airway. So if you extend your neck back, it is located up in this location.
I see. And your testimony is that in a person of this age, you would not expect that bone to have been fractured.
Correct.
But a person of advanced or older age,
Yes.
strangulation case, you would expect that bone to be fractured?
Yes.
In cases that may involve strangulation, do you always do a physical inspection of that if it's available?
Yes.
Now, you described the skeleton as being mostly that bones, but there was some flesh still remaining?
Yes, yes, there was.
In determining whether an injury is a perimortem or post-mortem, I think that you said that you normally examine tissues.
Yes.
And in this case, did you examine tissues?
There were very little to no tissue present. There was some skin present on the back of the head and neck, on her chest, her breasts, and her back. And then there was some skin left on her upper extremities and her lower extremities. All of the skin, with the exception of a small portion on her back, was exposed to the elements and was very leathery in color and consistency.
The examination of the remaining skin, was that helpful to you in making any type of determinations?
Well, what skin was present, we could determine that there were no injuries present, but again, the lack of the skin on the face and the neck didn't help us when we were trying to determine if strangulation was present, because again, simply, it wasn't there.
And if the skin had been still on the neck, that would have been helpful?
Yes.
How did you come to the conclusion that the injuries to the face, in your best opinion, were perimortem? What led you to that belief?
That would be how the fractures appeared, as well as consulting with the anthropologist.
And what led you to that conclusion?
Again, it would be the appearance of the edges of the wound, as opposed to this being a purely post-mortem phenomenon, or if this was an older injury that had already healed.
So there was no sign of healing?
Correct.
Okay. How long after an injury does a wound start to heal?
A wound can start to heal within a day, or even within a few hours on a microscopic or cellular level.
In your testimony, you indicated that perimortem, in your use of the term, means at the time of death or shortly thereafter.
Correct. It refers to the short period of time before, during, or immediately after death is perimortem.
What is a short period of time in medical jargon?
For most intent and purpose, it would be the few minutes before or the few minutes after. with regards to bones and fractures alone, not considering a soft tissue component, that can extend up to a few hours before or a few hours after.
So, in your testimony, the injuries to the face could have occurred a few hours after death?
Yes, based on just looking at the fracture itself, yes.
Right. Thank you. You testified as to a toxicology report, the condition of the body. Were you able to do any type of toxicology tests?
Well, traditionally, we will send off blood and urine specimens as well as the fluid from the eyes. In this case, we did not have those specimens. What we had was some skeletal muscle still present on her chest and some brain left within the head. We submitted those specimens for toxicology analysis.
Were there any results of that test?
The results performed in skeletal muscle were that there were no substances that they could detect.
And which substances have survived in skin for the length of time that the body was apparently there?
All I know are the things that they looked for, and the fact that decomposing and leathery skeletal muscle is not an ideal specimen. So we don't know truly what was in her bloodstream at the time of her death.
And was there a toxicology report that was prepared and sent to you?
Yes.
Is it attached to the report that you prepared?
It is a separate report, but if you request a copy of the autopsy report, it should be provided.
All right. Thank you. Now, for lack of a better term, let's talk about erotic asphyxia. Are you familiar with that phrase?
I'm familiar with autoerotic asphyxia and strangulation.
What about choking as part of sexual intercourse?
Yes.
Have you ever had autopsies where that was the cause of death?
No.
Never?
Correct. Never.
Okay. But you are aware of the practice and what is done in those circumstances?
Yes.
Now, you testified that, and this was, I think, in response to just questions about strangulation, that someone could, in fact, pass out in 20 or 30 seconds as a result of strangulation?
Yes.
But you further testified that there are many variables as far as how much additional time it would take for someone to pass out and then for someone to pass away. Would that be correct?
Yes, there is a passage of time and there are variables involved, yes.
In the variables, of course, I think you hit some high points. Variables would include a level of intoxication, for instance?
Yes.
How does that affect the time frame?
Essentially, your body only has a certain amount of oxygen reserves, and any level of intoxication or injury, say for instance 1 or 2 of these blows, essentially chip away at that store. So your body has less oxygen available to it, and it becomes more susceptible to the effects of asphyxiation or strangulation. So the short form answer is that any level of intoxication or additional injuries will shorten the amount of time it takes before the brain cells die.
And what about drug intoxication?
Yes.
Similar shortening?
Yes.
And what about physically infirm people who suffer from some type of medical condition which causes them to be weaker than the normal person?
Certainly if there's any underlying significant CNS or brain disorder or significant heart disease, they are less able to handle any additional insults to their bodies, such as asphyxiation.
So that would lower the amount of time?
Yes.
Okay. Just so I'm clear, you did not rule out asphyxiation as a cause of death?
That is correct.
Simply because you could not reach a result based on missing things, correct?
Yes, that everything that we would use to examine to make that determination is no longer present in the body.
All right, thank you. One second. Doctor, in your expert opinion, would it be, have you ever known a case where somebody has been strangled for 20 or 30 seconds, passed out, and never woke back up?
No.
You said something in response to one of Mr. Rohr's question about someone who might be brought back by CPR.
Yes.
When would that point be reached in the regular case?
It is, if you think about it, the point of no return, meaning that without CPR they still would die. That is individual for each person. If you examine the literature on near strangulation victims, so these are individuals who survived the act, there is some evidence there that it is closer to the minute mark than to the second mark. But again, it is variable.
What literature do you review on cases like that? Is there anything in particular that's a gospel of near strangulation cases?
No, but most of that literature is in the emergency medicine or the emergency literature and those journals. They are the ones that have published studies on near strangulation victims.
Emergency journals?
Yes, emergency medicine.
Okay. Is there a journal of emergency medicine?
There might be. There are a lot of journals for that specialty.
Okay. Now, as far as the blunt force trauma to the head, I think in response to Mr. Rohr's questions, you said that, and correct me if I'm wrong, I'm not trying to put words in your mouth, my approach. I believe you testified that particular log or tree or whatever it is, the way that it's positioned, if it fell on the victim and the victim were there, that you'd expect damage or fractures to the ribs?
Yes. It could, if it first fell on her face, it could explain some of the fractures, either the centrally located ones or the ones on the right side, but not all of them. Then, if the log could roll, which I don't know if this particular log would have rolled off of her face, if it was of such weight to cause those fractures, we should expect to see some injuries to the ribs, at least one fracture, or if it is of equal weight on both sides, symmetrical rib fractures, and she did not have any chest or rib injuries.
You would agree, would you not, that that log may not be in the same position it was earlier?
Correct. I do not know what position that log was in.
Okay. For instance, if this log was dropped from a vertical upright position down, would you expect it to cause significant injuries if it hit a decedent's skull?
Yes, but again, not all of the fractures.
How about if this log, this other companion log, were dropped the same way?
A heavy object either being dropped twice or two heavy objects in certain locations could explain all of the fractures to her face.
Thank you, Doctor. No further questions, Your Honor.
Redirect.
Just briefly, just to clarify this then, is your ultimate opinion that the blunt force trauma was the cause of death, but you simply cannot rule out the possibility of asphyxia as well?
Yes.
All right. Is it a myth that people die as a result of strangulation during sex?
If an individual is engaging in rough sex and they end up dying, it's because they strangled. That the pressure was placed on their neck long enough beyond the point of consciousness so that the brain cells are depleted of oxygen.
And is it your testimony that the length of time post-consciousness to strangle someone to death is 2 to 2.5 minutes?
Yes, if there are no other factors involved that would shorten that length of time, yes.
And then you've conducted somewhere around 7,000 forensic exams during your career, and 50 of those or so have been involving strangulation, is that right?
Yes, I've autopsied more that are of asphyxial or accidental or suicidal asphyxial deaths, but around 50 actual strangulation homicides.
All right. And is it your testimony that none of those involved erotic asphyxiation?
Some of them may have involved circumstances that arose during sex, but all of those victims were strangled to death.
All right. Thank you. No other questions.
Got some follow-up.
Cross?
Yes.
On the issues just raised on redirect.
Yes. Doctor, your testimony is that the length of time it takes to die by strangulation depends on various factors, correct?
Yes.
And your testimony also is that there have been autopsies that you have done regarding erotic strangulation?
Again, some of the cases may have arisen during the act of sex, but all of those victims were strangled. That's my testimony.
So you don't have a distinction between strangulation out of rage and strangulation out of sex?
Correct. Strangulation resulting in death is death caused by another person, and that is our definition of homicide.
Thank you for clearing that up. Nothing further, Judge.
Nothing further. All right. Does anyone wish for Dr. Laverty to remain as a witness?
No, Judge.
Thank you for your testimony. You're free to go, or you may stay if you wish.
Thank you.
And I believe our final witness will be Detective Defendant.
Okay. Detective Fred Williams. Please pause at the glass and raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is true?
I do.
Have a seat in the witness chair to my left. Please recite and spell your entire name for the court reporter.
Michael Predmore, Michael
Go right ahead.
Thank you. Are you employed?
Yes,
By?
Monroe County Sheriff's Department.
In what capacity?
Detective,
How long have you been with the department?
almost 14 years,
And how long have you been a detective?
2 years.
Were you a detective with the department back in October of 2014?
Yes,
And did you participate in the at first missing person report involving Chelsea and ultimately in her homicide investigation?
yes,
Sorry, directing your attention to April 24th of 2015, did you go to the Briar Hill site where Chelsea's body was located?
yes, I did.
All right. Judge, I believe we have a stipulation as to the admission of People's Exhibit number 2.
True? Yes.
All right. And Detective, that exhibit that I just handed you, is that a fair and accurate reflection of the scene as you saw it that day?
Yes,
Where everybody was looking? All right. Now, I would like to fast forward then to July of this year. Once the CODIS hit came in, there's been some testimony about that and the fact that the following day the defendant was located and taken into custody. Is that your recollection?
yes,
Okay. And he was taken to the Monroe County Jail
yes,
and interviewed there?
yes,
As part of that process, did he, either voluntarily or through the process of a search warrant, yield to a buccal swab of his DNA?
Yes.
All right. And is that the buccal swab that was ultimately sent to and analyzed by the Michigan State Police Crime Laboratory technicians who testified earlier for confirmation purposes?
Yes.
All right, then, with respect to the interview itself, we've had a fair amount of testimony on it, and I don't want to belabor the point, but is it fair to say that when the interview began, the defendant claimed no knowledge whatsoever of Chelsea Brooke or her being missing or ultimately her death?
That's correct.
And during the course of the interview of the defendant, did his position continue and repeatedly evolve?
Yes.
At some point, then, did he admit that he had, in fact, been outside the party with Chelsea and claimed that she had died during sexual intercourse?
Yes.
Would you please describe what he said to you in that regard?
He described while he and Chelsea were having sexual intercourse in the back seat of his vehicle, that the sex got rough, freaky. She asked him to choke her and slap her around a little bit. And while the course of, having sex and choking her, she went limp. And then he stopped having intercourse with her and, checked on her because he believed that she may have possibly passed out. When he couldn't get her awake or anything, then he realized that something was wrong. He said he tried to perform CPR. He also tried checking her breathing status by holding a mirror in front of her mouth.
Did he indicate to you how her, now, you may have used the word pants, but your understanding that she was actually wearing tights or something like that rather than pants?
Correct.
Okay, so if we use that term interchangeably, did you ask the defendant, and by the way, do you see the defendant present in court today?
I do, yes.
All right, would you please point to where he's seated and what he's wearing?
He's wearing a jail uniform with glasses on his head, bald head.
The record will reflect that the witnesses positively identified the defendant.
Thank you. Did you ask him how her pants or tights had been removed?
Yes.
What did he say?
He described them as both him and her removing her clothes, each other offering assistance to get the clothes off.
Did he admit to anything that suggested that the garment had been torn in 3 different places?
At first he did not, but when I brought it up that the garment was torn, he said between him and her pulling on it, there was a possibility that it could have tore when they were taking it off.
So, as the as he described, then immediately following his realization anyway that she was dead, what did he tell you he did?
He said he panicked. He drove around, not sure, he didn't know what to do. And while driving around, the course of driving around, he ultimately ended up in the Briar Hill area, the Briar Hill site.
Well, you say he claimed not to know what to do. Did he, for example, give any indication that he drove Chelsea to the hospital for medical care?
He did not.
Or did he contact 911?
No.
Did he in any way, shape, or form report the fact that she had died?
No.
In fact, through July of this year, did he ever report to anyone, so far as you know, anyone in a position of authority that Chelsea had died?
No.
And once at the Briar Hill site, what did he claim to have done?
Once he arrived at the Briar Hill site, he said that he pulled his vehicle down the railroad tracks, down the entrance, those small two-track of the railroad tracks next to it. Once he parked, he got out and he took Chelsea's unclothed body and took her into the woods where he found a place to lay her down. And then he ultimately threw logs, sticks, twigs, logs, and leaves on her. Once he did that, he said that he sat there for approximately 20 minutes crying, not sure what to do. You know, and then he ultimately got up and left and went back home to Americana.
Of course, that was one statement that he made. He also made a separate statement as to where he put his car before he placed her in those woods. Is that correct?
I remember him telling me that he pulled his car down the tracks and parked his car along the tracks on the gravel drive.
Did he claim also to have parked elsewhere and walked down those tracks? That you recall?
I do not recall that.
Okay. Is that road, that access road that we've talked about some today, is that the same place where the Michigan State Police Crime Lab located the leaf that was ultimately analyzed by Jennifer Risk at the crime lab?
Yes.
And that was found to be part of Chelsea's costume. Is that your understanding?
That's my understanding, yes.
During the course of your interview with the defendant, how would you say the relations between the three of you, it was you, Detective Soroka, and in the room, is that right?
Yes.
How would you describe those relations?
Just a general discussion. Never got heated. We spoke, clear. No one really ever raised their voice. There was no arguments. It was a discussion as you and I are having right now.
At various points, did you get him things that he had asked for?
Yes.
Like what?
Water, bathroom break, cigarettes, and pizza at the end, something to eat.
What about some telephone numbers?
Yes.
What was the point of that?
Throughout the interview, he asked me about getting his telephone, retrieving his telephone for him, and retrieving some phone numbers off from his telephone so he could make some phone calls after we were done. Once the interview was completed and the necessary notifications were made, I returned back and I took the phone to him and allowed him to get phone numbers off from that telephone.
Is it safe to say that the entire interview was recorded?
Yes.
And when you left the room, well, first of all, when you gave him the phone, did you immediately leave the room, or were you in the room for part of that time?
First of all, when I brought his cell phone into the room, I accessed his cell phone with this help, getting the phone numbers that he wanted off. Once I wrote those phone numbers down, I provided him with a telephone, and then I left the room.
And did the recording device remain on?
Yes.
And did he in fact make several telephone calls?
Yes, he did.
And during the course of any of those calls, did he mention anything regarding Chelsea or what he had done?
Yes.
And can you recount that from the court?
When he made telephone calls, he describing to the person on the other line, to multiple people, that he was incarcerated for the girl at the Halloween party. He referenced her as Chelsea Bruck. He killed her, and then he dumped her body, and that was her. That he did that.
No other questions?
Ross?
Thank you. Detective, during your custodial interrogation with my client, did he tell you that he was engaged in consensual rough sex with Chelsea Bruck?
Yes.
Did he also state that Ms. Bruck asked him to do it harder and choke her?
Yes.
And he admitted that he did choke her during the sex?
Yes.
At her request?
Yes.
Did he ever tell you that he murdered her?
He did not, no.
But he did tell you that he was having rough sex?
Yes.
Asked to be choked and then passed out at a certain point?
Yes.
Detective, at some point, did Mr. Clay ask about consulting with an attorney?
He inquired about an attorney, yes.
And when was the first time during the statement that he inquired about consulting with an attorney?
When the DNA was introduced.
So you told him that there was DNA that matched him with the decedent?
Yes.
And he asked about consulting with an attorney?
Yes.
What did you tell him?
I told him that was his right. I explained to him that he could have an attorney present while we were questioning, and if he wanted the attorney, then we would stop questioning and I would take him down to Monroe County Jail.
And at that point, was that the first time that he had asked about consulting an attorney?
That was the first time, yes.
Okay. And at that point, did he tell you that it was okay? Did he want to continue?
He wanted to continue, yes.
Now, was there another time during this sequence that he asked to consult with an attorney?
Yes.
Did he ask if he could have a lawyer brought to the sheriff's office to speak with him during the interview?
He did.
And was he provided with an attorney?
Not at that time, no.
And why not?
I advised him that it was Monday, or it was Friday at 6:30 p.m., and that it was almost impossible to get an attorney down there at that time. I told him that I had a lot to discuss with him, but it was his right and that I would not speak to him anymore if he wanted an attorney present, that I would take him down to the Monroe County Jail and cease the interview.
So, you told him that you couldn't get an attorney at 6:30 on a Friday, right?
I couldn't. That's what I told him, yes.
Now, in those requests to consult with an attorney, how long was there between the first request and the second request? Just
I would have to guess.
What's your best estimate? It's not a trick question. I'm not trying to trick you.
Maybe an hour.
Okay. And to your knowledge, were those the only two times that he requested the right to consult with an attorney?
Yes.
Now, between the first request for an attorney and the second, was he provided with anything like cigarettes?
Trying to remember back, I know he was provided with cigarettes after the first request. I believe it was before the second request.
To the second request, was he provided with cigarettes or pizza?
That he was provided with the pizza after the interview was conducted. The cigarettes he was provided, and I don't want to guess here.
No, it's not. Again,
he was provided with a bathroom break, and right after the bathroom break is when he, made the other request and asked.
Okay. Did he ever, during your interview with him, ask you if it would be a good idea for him to have a lawyer?
I never heard him say that it would be a good idea.
Did he ask you if it would be a good idea?
I cannot remember. I can't recall.
And, Detective, there is a DVD of the entire interrogation.
Yes, there is.
Now, did you ever promise him anything?
The phone numbers at the end, that I would give him his phone numbers.
Okay. Did you ever tell him that it would be better for him if he told you everything that happened?
Well, that it would look better for him if
Yeah.
he told me the whole truth? Yes.
Okay. And, but you never promised him any type of consideration for giving a statement. Is that your testimony?
No.
Did he voluntarily provide you with a sample of his DNA upon request?
Yes, he did. Detective Soroka, he provided it to.
But he signed a
A
consent?
consent form, correct.
Okay. That's it. Thank you.
Thank you.
Redirect?
Just briefly, in either of those instances where the defendant mentioned an attorney, did you perceive that as a clear, unambiguous assertion of his right to counsel?
I took it as he was asking a question, and I provided him, I told him what he can do and what would happen upon his choice. I made sure that it was clear that if he wanted an attorney present, that he could have an attorney. I also made it clear that it was his choice if we continued. At one point, I even told him to look me in the face and make sure that this is what he wanted, and he didn't want an attorney if we proceeded, and he said yes.
So in both instances, it was his choice to proceed?
Yes.
Thank you. No other questions?
Across on that issue,
No, Judge, I'm satisfied.
anyone wish for Detective Prevenberg to remain as a witness?
No, thank you.
No, Your Honor.
Thank you. You're free to go.
Thank you, sir.
Welcome to stay. Any other testimony?
No.
Then the people rest. Should people rest?
Yes.
I'm sorry. Any testimony from the defense?
Not today, Judge.
Argument?
Well, Judge, I would,
By the way, this is off of the amended complaint dated September 22, 2016, correct? There were two amended complaints.
November 22nd, right?
What's that?
Yeah, that's the one we're operating under at the
Yeah.
moment. Right, but at this point in time, I think what I would do, Judge, rather than recite heavy facts, I would just move the court with the law and then reserve the right to rebut as necessary. But we would move to bind over on two counts. And count one would be open murder, which includes first-degree premeditated murder, second-degree murder, and felony murder. That's under MCL 750.316. I do, by the way, have an amended complaint for the court that might simplify things, assuming that that's the direction you end up going, as well as binding over on count two, the stated count two, concealing the death of an individual. I would just point to the fact that murder is defined by statute and may be first, second, or felony murder. There's a case, People v. Herndon, a 2001 case, 246 Mishap 371, that stands for that proposition. Also, MCL 767.71 stands for the proposition that it shall be sufficient in any indictment for murder to charge that the defendant did murder the deceased, rather than, for example, it shall not be necessary to set forth the manner in which or the means by which the death of the deceased was caused. People are not required to specify the degree of murder at issue. That's from a variety of cases, including a 2000 case, People v. Ball, which is 243 Mishap 1. And additionally, the people need not, as the court probably is aware, need not present evidence of premeditation and deliberation during the preliminary examination to support a binder on a charge of open murder. That's from Ball and also a variety of other cases. So, in short, we believe that the testimony presented to the court demonstrates by probable cause that the defendant did murder Chelsea Ellen Bruck, and in count two that he concealed her death, knowing that she was dead. He failed to inform law enforcement, or funeral home or 911, and the purpose of doing so was to conceal the fact or cause of death of Chelsea Bruck. And I would reserve argument beyond that.
Mr. Smith?
Judge, the charges which Mr. Clay faced in this matter going into the preliminary examination were homicide, murder, second degree. concealing the death of an individual. I believe that those charges were greatly thought out by the prosecutor before they were filed. There's no other reason that they would have picked murder second other than that's what they believe possibly occurred at this date and time. Now they're seeking to ask this court to bind over on open murder, which is not a surprise. I'm not claiming surprise, but I do not believe that it is justified under the facts that this court has heard today. Of course, this court is also aware that the preliminary examination in a criminal case requires the absolute least proof of any burden of proof that there is in the criminal justice system. So I urge the court to resist the temptation to amend the charges against Mr. Clay. If the court is going to bind him over, I'd ask that he be bound over on the charges that he is in fact facing.
Well, again, we don't have to provide the court with evidence of premeditation and deliberation, although we have. We have, through Dr. Lavity, for example, we've demonstrated that even though the defendant claims in his statement the final iteration of his various statements, I might add, he claims to have more or less accidentally killed Chelsea Bruck. The testimony from Dr. Lavity makes clear the fact that that could not have happened. She clearly indicated that although 20 to 30 seconds would be sufficient to cause someone to lose consciousness, it would be an additional 2 to 2.5 minutes of constant strangulation in order to cause death. And that is more than enough time to consider options and premeditate, that is to say, what's happening. And we believe that's exactly what happened here. Not to mention the fact that Dr. Lavity testified that her principal cause of death was blunt force trauma to Chelsea's face, which certainly, she could not have consented to that, even if there is reason to believe that she engaged in a consensual sexual relationship act with the defendant that evening. She certainly cannot consent to being bludgeoned to death, and that certainly would be evidence of premeditation and or the commission of a homicide or a homicide during the commission of a felony. So we believe that there's more than adequate evidence presented to the court today to bind over on open murder as well as counsel.
Okay. This is preliminary examination, and it carries the lowest burden of proof in practically all the law, but definitely in all of the criminal law. It merely be shown today that there's probable cause to believe that a crime was committed and that the defendant committed it. As to the count 2, concealing the death of an individual, there's no doubt in my mind that from the statements of the defendant and which is buttressed by the statements of the people who were at the party. I say buttressed, which I mean can be inferred from the people who were at the party that he knew that this decedent, Chelsea Bruck, was dead, and he himself said he drove around for 30 to 45 minutes and then he hid the body and he never reported it. So there's no doubt that crime, which states that a person who knows or has reason to know that another is dead and fails to inform law enforcement, a funeral home, or a 911 operator of the discovery while having purpose to conceal that fact or cause of death is guilty of concealing a death. And I find there's probable cause to bind him over on that. The prosecutor now is asking me to bind over on open murder after having originally charged murder in the second degree. And it is true that in open murder, the nature of that charge is to not choose a first degree or a second degree. That ultimate decision is by the fact finder. And at a preliminary examination where there may be a reasonable person may believe that the crime occurred, another reasonable person may believe that it didn't, case law states that I'm duty-bound to bind over to allow the ultimate fact finder to arrive at the decision. I think there's been substantial testimony here today, and I'm very impressed with the testimony of the medical examiner that is in direct contradiction with the statement of the defendant as to how this thing happened. And I don't believe for a minute that any logs falling in the woods caused these damages to her face within a few minutes or within a few hours after her death. So I find that there's both probable cause to believe that the crime of first-degree, second-degree murder, or even manslaughter may have been committed, and there's probable cause to believe that the defendant committed it. Therefore, he's bound over also on the charge of open murder.
Judge, if I may, I'm sorry, just to clarify that, I believe that open murder includes first-degree, second-degree, and felony murder, not manslaughter.
Felony murder.
Thank
you for the correction. That was my intention. Thank you.
Thank you, Judge.
You're welcome.
Thank you.
Arraignment date, Judge.
The matter not cognizable by the district court. Defendant's bound over to appear in circuit court on November 10 at 1:30.
Is that a Thursday, Judge?
Yes, the 11th is Veterans Day, which we're all probably going to celebrate.
Oh, absolutely. Thursday at 1:30.
Okay.
All rise, please. Court's in recess. Master control. Got Daniel Clay coming back from Vice Alley's. Can somebody meet Detective at the bridge?
He's got to do something to this.
Got a what?
He's got to do something to this real quick. I don't know if it
Okay.
has something to do with the front feature or not.
They're going to meet you at the bridge, but I got to give you a copy of the ROA, so